Michael, thank you so much for inviting me here, and thank you so much for assigning me to talk about David's paper. It's a wonderful paper. It's extremely fair-minded. It looks at all sorts of contrary evidence. It never tries to hide the ball about what it's doing. He really goes through everything, and I think he creates a very powerful and convincing case, certainly convinced me that we have not given the Republicans of the period immediately after ratification enough credit for their egalitarianism. And so that's one of the big takeaways I take from the paper. There are other things too, but unfortunately, I am asked to give commentary on it, so now I have to find things to nitpick about, so I will nitpick. But I guess what I'm going to do is in the form of ways of thinking about what additional research one could do to sort of figure out the thesis. So we can put them roughly into three categories. One is, what's the relationship between the Civil Rights Act and the 14th Amendment? That's the first question. The second is, what's the relationship between common law rights and the Privileges or Immunities Clause? And then a subheading, what's the relationship of Section 5 to that question? And then the third question is, this is a paper about original understanding, and to what extent does this paper have the kinds of problems that original understanding originalism faces as opposed to original meaning originalism? That's number three. And number four is, David's talked about the idea of the burden of proof, and my question is, for what purpose? In other words, it depends on what question we want to know, how much of a burden of proof we want to put on David's conclusions. So I want to talk about different kinds of questions we might be interested in. So first of all, the puzzle that David's article raises for us is the following. There's very good evidence that the people who wrote the Civil Rights Act of 1866 did not want to touch racial endogamy laws, and said so, and Trumbull said so, and others did. But David also wants to say that doesn't tell us anything about what the 14th Amendment did. And that's a puzzle because most of the literature has always assumed that there's some linkage between them. And we can talk about this both in terms of the question of privileges or immunities, but we can also talk about it in terms of politics. So in 1866, one of the reasons why Trumbull and these folks are trying to give assurances that this would not touch laws about intermarriage was that it was political suicide, or at least they believed at that period it was political suicide to do so. And therefore, they started to create what would later become seen as the distinctions between political, civil, and social rights. And in fact, those distinctions really come out of that. And what they are is they're flipping on their head, I'll get to this in a second, the positions that people had, that is the slaveholders had about citizenship and rights. What they're doing is they're twisting them, right, in order to get the Civil Rights Act passed. So, but the problem is that the Civil Rights Act is debated and passed in March. The debates on the 14th Amendment are happening right around the same time. Why would they be so careful as to deny that it would touch intermarriage and then go out, which only required a simple majority in both houses of Congress, or actually required overturning the president's veto, but then go on to pass something that would require supermajorities both in Congress and in the states? In other words, the only reason that would be the case is if they, one, they didn't mean to do that, or two, they secretly meant to do it, but they didn't want to tell anybody that that was the effect of the law. Well, that creates a sort of theoretical problem for theories of original meaning versus original understanding, original intention, you see. So that's the puzzle. That's what the puzzle I'm left with after I read it. It looks like they're pulling a fast one on everybody else, because it looks like they're playing a bait and switch. We just told you this about this statute, and what we're not going to do for a statute that would take a lot more work to get right. This is actually a common. Theme between both my book and Mike Rappaport's book. Mike's book says rights that are protected are rights that at the time of enactment are those that you can expect there will be a large consensus among the ratifiers for. That's how we can tell that the supermajority rule is likely to be a good one. So that means that there has to be publicity about what the consequences of the proposed right are going to be. My view is the opposite view. The constitutions are usually written in a way to basically paper over things and not tell you what's going to happen. They'll work it out later, right? But I just want to point out that that leads you down a different path, you see? And David's not taking my path, right? But I don't think he can quite show what Michael wants him to show. So that's the first puzzle. Here's the second puzzle. The second puzzle has to do with privileges or immunities. And one of the great things about David's paper is he shows you that there's this common law right that existed with respect to marriage, and statutes that banned interracial marriage were in derogation of the common law right. And he says that the whole point of the privileges or immunities clause was to relieve that burden. Right? So that's why it's an immunity. It's an immunity from statutes and derogation of the common law. So that's very clever, very smart, and it took a lot of interesting research to find, but it leads to the following interesting question. Why do we think that common law rights in general were privileges or immunities of citizens of the United States? That is to say, another way of asking the question is, why do we think that the privilege or immunities clause constitutionalized common law rights? And here I have to give a shout out to Kurt Lash, whose work at this period of time when I was working on my book was extremely influential to me, when he was pointing out that if you actually looked at the way that people are debating the question of privileges or immunities, there were some folks who were perfectly happy to constitutionalize common law rights, but there were a whole bunch of people who were not. And the reason they were not happy to constitutionalize common law rights is they were not worried about Section 1, they were worried about Section 5. That is, the problem was that if you constitutionalize a common law right, and you say in Section 5 that Congress has the power to enforce all the provisions of the 14th Amendment, including the privileges or immunities, it would essentially give Congress the power to enforce and protect common law rights. And this is an argument that gets made again in the slaughterhouse cases. And it's one of the arguments that scares off the court in the slaughterhouse cases. So what does this have to do with David's thesis? Well, there's the general problem, which is how much common law stuff was constitutionalized. But the second problem is, if it's a privilege or immunity because it's a common law right, then it would seem to follow, although I think there are ways out of the conclusion, that Congress would now have the power to pass laws regulating marriage at a national level. There are ways out of this conclusion. I can think of some of them. One is privilege or immunity is only about equality. Right? It only guarantees equality of rights, but not substantive protection. But David has closed that door to me because he doesn't want to take that position, right? But that would be a solution. And by the way, that's the solution that I drew from reading Kurt's work. That is, that Kurt said to the extent that common law rights are brought in, they're brought in a sort of equality way, and that would be a solution to the problem. But if you want to say there's a substantive right to marriage that's being protected, then you have the Section 5 problem. Okay. Third issue is the relationship between original understanding and original meaning. One reason why originalists moved to original meaning was that original understanding, originalism, created lots of problems. One of the problems was it was very difficult to show consensus among the relevant group, framers, ratifiers, general public. And David's paper, which amasses a wonderful amount of evidence here, nevertheless still faces this problem. So, for example, what we have to do is we have to create inferences from the record. So, for example, after the ratification of the 14th Amendment, the political incentives are different than before the ratification of the 14th Amendment. After the ratification, you want to go for the gusto because it's already on the books. Before the ratification, there are certain things you won't say because you don't want to scare people off. But even so, after the ratification, the mere fact that laws are repealed doesn't tell you that the people who repealed them believe they were constitutionally required to repeal them. A good example is Lawrence versus Texas. By the time the court decides Lawrence versus Texas, most states have either repealed their sodomy statutes or are no longer enforcing them, very similar to this problem. But it didn't follow that every state that did so because it thought it was constitutionally compelled. They might have thought that was just fair, or good public policy, or decent, or it was, in the words of Clarence Thomas, an uncommonly silly law, quoting Justice Stewart, right? In other words, they could have been making an argument for this is a bad thing to do, but we don't think that the Constitution requires us to do it. So in order to make the argument, we have to kind of infer that. And sometimes inferring is okay. It's just that it creates a problem you have to deal with. Another problem Another example of the problem is what Reva Sevico calls preservation through transformation. Before the Civil War, this is a point that David makes, and I think it's great that he makes it. If you were a defender of slavery and against black citizenship, you would say if you give black citizenship, they're going to get a whole panoply of rights, including not only the right to bear arms, heaven forfend, right, but also they can marry people of a different race. So in other words, in order to fight against black citizenship, you just build up and thicken the concept of citizenship. After it looks like blacks are going to become citizens, the positions reverse. Right? So now the defenders of black citizenship want a thicker conception of citizenship, while the opponents of black citizenship, or the people who want to limit the 14th Amendment, now try to thin out and hollow out citizenship. And it's precisely the fight between these two groups that leads to the tripartite conception of political, civil, social. But each of them is flipping from the positions they had before. Now, if you're trying to get in a sense of original understanding, you have to figure some way to understand why parties would do this and why they would take certain positions at certain times in the process. And again, you can do it, it's just difficult, and that's a problem. Let me end with the last point. David says that the goal of his paper is to meet a burden of proof about whether or not racial endogamy laws were unconstitutional at the time of the 14th Amendment. For my purposes, he has met the burden of proof. I am delighted to read this paper. This is a wonderful paper, but it begs an interesting question, which is, what is the question for which the burden of proof is being asked? In other words, it's not like we are here openly asking whether or not we should overturn Loving versus Virginia, right? Nobody in the room, I take it, wants to get rid of Loving versus Virginia. So in terms of the burden of proof of whether or not Loving versus Virginia is a good decision, believe me, you had me at hello, right? You know, it's not that difficult. Another possibility is that the goal of the paper is to shore up particular criticisms against particular forms of originalism, right? Well, that's possible, and certainly, you know, when Mike wrote his paper, that was not the only goal, but it was one of the goals of his paper, was to say that people kept beating him over the head and shoulders by saying, you can't explain Brown, you can't explain Brown, and then Michael said, oh, yes, I can. Oh, and by the way, I just want to point out, this paper strengthens Michael's paper in retrospect. I just want you to understand that Michael's argument is strengthened by the evidence, even though it's not directly on point, it adds to the point that he's making. So if that's the point of the paper, well, yes, but then you're going to get pushback from people who aren't committed to a particular theory of originalism, and they'll ask you to prove it. That's not, you know, I don't have a dog in that particular fight. I do have one particular dog in one particular fight, and that's where I'll close, which is this. Raoul Berger did us a disservice in the way in which he did the first generation of originalism. Because the way in which Raoul Berger portrayed the Reconstruction Republicans was, and I will use the word, he called them Negrophobes. That is to say, they were sort of dragged kicking and screaming into giving black people equal rights. And that's the way he portrayed what the debates over the 14th Amendment were about. And he kind of sort of set an anchor point, which shaped a lot of the debate that came later. Of course, he was helped also by Fairman and by Bickel, who also had this more or less as you all, not as extreme as Berger's did. And one way of thinking about, and I put Michael's work in this category as well as David's, is to reevaluate what these Reconstruction Republicans were doing and what they actually thought. And the picture of them that emerges after reading Michael's work and after reading David's work is a group of people much more idealistic, even though they were politicians, much more egalitarian than modern day people are willing to give them credit for. That's important, I think, for all kinds of originalism, because it shows you the importance of the link between the issues that we are facing today and the issues they faced in their day. Thank you.